All right, for the record, you are Austin Harrouff?
Yes, sir.
All right. Anybody want to begin?
Yes, sir. And we did speak to the defense last week, and we have agreed that Your Honor can take into consideration the reports from law enforcement officer, the court file, the evidence marked 1 through 36 from the state to make this determination. So essentially, you just have to determine based on the reports and the facts that are on these exhibits.
With regard to, is the state stipulating to the defense's claim of insanity at the time of the offense?
Well, obviously, you can't stipulate, as you know, it has to be a court finding by Your Honor or the jury, and the defendant did sign a waiver of jury trial on March 1st, 2022, and that was filed with the court on June 13th, 2022. And again, the defense is stipulating that the defendant did commit the acts as he was indicted for the 2 homicides, the attempted murder, and the burglary of the dwelling.
And to make it easier, Judge, we have agreed both sides to the proposed order that's been presented to Your Honor. We have no objection to the state's exhibits being entered into evidence, as well as the exhibits we're offering, which the state has no objection to, which are the St. Mary's records, the jail medical records. We're both offering the resident and Landrum reports, as well as the doctrine. And we have no objection to the court taking the offense report as an exhibit.
So I'm just trying to get this straight. So the state, the defense are not agreeing to, which has occurred every other time that it's occurred, that in other cases, that the defendant was insane at the time of the offense and therefore would be not guilty by insanity, but you are asking the court to make that finding based upon what has been filed in the court file. Is that accurate?
Well, it's about, my understanding, we have agreed to that order, so if you enter.
You didn't say that.
Well, we had agreed to this order, and I can get it to Your Honor.
So the state is not objecting to the finding of not guilty by reason of insanity and commitment to the department.
Correct, and the defense is agreeing that the defendant is in danger and it's here.
Should be committed. Okay. Well, then based upon that, then the court is prepared to make that finding since it's agreed to. Does anyone wish to speak? Is that what?
What Judge, I think you still have to review the evidence and make your own findings. And it is, again, say we move in 1 through 36 or 1 through 36, the defense agrees to that. But I do, those two, including Dr. Landrum's report, as well as Dr. Resnick's report, some photographs from the scene, the medical examiner's reports, and records from the jail.
Okay. I like clarity, so I'm going to try to make this as clear as I possibly can. Is the state and the defense, specifically the state, requesting the court to be the one to make the ultimate finding, or is the state agreeing that legally that finding should be made?
We are agreeing with that, but I think you still need to make that finding because of the case law.
Well, I understand that, but I'm getting the impression that the state's not wanting to jump in with both feet. So I'm trying to get some clarity on this, because if I'm going to make the finding with regard to the events as well as that, I don't have a problem doing that. It's just,
if you look at the proposed order, if the defense agreed to, it states, I think it's one towards the end there, and I can tell you what page. It does say that the defense, it's item number 5, the state and the defense stipulate and agree that the defendant was not legally sane at the time of the offense, and therefore is not guilty of the offense by reason of insanity. However,
Right.
while we can say that, we still need a finding from Your Honor.
Okay. So you're agreeing to an order, I make that finding, but you're not saying it. Okay.
Following the case.
I understand, but it'd be nice if the court's making the finding that the state is stipulating and agreeing in an order, that means that the defense and the state stipulated and agreed. Yes?
We can't see.
Okay, you don't have to say it.